Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Welcome to another episode of Time is Not on Your Side. I'm Robert Eckard, board-certified business litigation attorney and government investigation specialist. Today's topic, what fiduciary duties do I owe as a director of a Florida or Delaware corporation? So you're a business owner or an entrepreneur and you form your first company and suddenly you carry the title of founder, director, officer, and employee all at once. Running your business may feel like all of your roles blur together. However, it's important to remember your different roles when taking action on behalf of the corporation in order to protect yourself from liability. A fiduciary is someone who's required to act for the benefit of another person on all matters within the scope of their relationship. Officers and directors of a corporation are fiduciaries, and under Florida and Delaware law, the general rule is that a director owes fiduciary duties of loyalty and care to the corporation and its stockholders. So what is the duty of care? The duty of care mandates the director act in the good faith with the care that a reasonable person in a similar position and circumstance would exercise in a manner that the director reasonably believes to be in the best interest of the corporation and stockholders. Put simply, directors must inform themselves of all necessary available material information and make deliberate, carefully prior decisions before they make those decisions. For example, a director should take appropriate time to evaluate corporation actions, take advice from experts, and actively ask questions and take the time to understand transaction and review management. It's important that directors deliberate and properly approve and document certain corporate actions in order to avoid liability for breach in their duty of care, as well as ensure corporate records are adequately maintained and ready for potential inspection by investors and other shareholders. So what's the business judgment rule? If you're sued for breaching your duty of care as a director, the default standard is that your actions will be evaluated under the business judgment rule. Appropriately named, the business judgment rule, it protects directors from lawsuits that challenge their business judgment. The business judgment rule is a presumption, and in making a business decision, the directors of a corporation acted on an informed, good faith basis and with the honest belief that the action taken was in the best interest of the company. When the business judgment rule applies, a court will not substitute its judgment for the board of directors as long as there's been a rational business purpose. Even bad decisions may be protected by the business judgment rule. The business judgment rule also protects good faith reliance on the records of the corporation and information, opinions, reports, or statements presented to the corporation by officers and directors, committees on the corporation, and people reasonably selected to rely upon that professional competence. However, the business judgment rule presumption is rebuttable. I mean, it doesn't always save the day. If a plaintiff can show certain conditions such as fraud, illegality, or wrongful conduct, a conflict of interest, bad faith, or egregious decisions or waste, the business judgment rule will not apply and liability will attach. So even if the business judgment rule does not apply, a plaintiff must prove a breach of the duty of care by showing that the board acted with gross negligence. In one case I had, a director breached the duty of care where, deciding to accept the merger proposal, the director on the board based its decision on one uninformed representation of documentation without doing any further research. Thus, gross negligence can be found where a board fails to inform itself of all readily available material and information before acting. Therefore, in order to avoid liability for the breach of duty of care, business directors need to keep informed and obtain information and decide if there's reasonably alternative measures. The duty of loyalty. The duty of loyalty mandates that a director acted in good faith and with a reasonable belief that he does it in the best interest of the corporation. A director must refrain from self-dealing, place the interests of the corporations and its stockholders ahead of his own. The duty of loyalty issues often arise in conflict of interest transactions, such transactions between two corporations when a director sits on the board of one company and on the board of another company, or usurps a corporate opportunity without first offering it to the corporation, or when a director is involved in setting his own compensation. Therefore, in order to avoid liability for breach of your duty of loyalty, you must avoid refrain from self-dealing and possibly recuse yourself from matters that require to do so, and make those disclosures to the board of all disinterested members. Defenses to liability. While the business judgment rule applies to evaluate the duty of care claims, it does not apply to conflict of interest transactions. However, a conflict of interest transaction can be cleansed if the transaction is approved by a voted majority of informed disinterested directors involved in the transaction, or it's been shown to be, in all due respects, actively vetted. Are fiduciary duties waivable? The short answer is no. As a director of a corporation, your fiduciary duties cannot be disclaimed or modified by agreement. Note, however, that Delaware law allows a corporation to indemnify directors for certain breaches of fiduciary duty claims, as well as provide for a waiver that allows for a director to take otherwise impermissible actions such as corporate opportunities. What corporate actions under Florida and Delaware law must the corporation board approve? As a director, you are responsible for managing and directing the business and affairs of the corporation. While the board can delegate management of day-to-day affairs of the corporation to officers, fundamental corporate changes in most material transactions must be approved by the board. This includes amending the charter, the bylaws, granting equity, adopting or amending employee equity or benefit plans, making material expenditures outside of the budget, and entering into mergers and acquisitions. There's no hard and fast rule about which actions must be approved by the board, and the list I just identified is not an exhaustive one. As always, you best to check with your legal counsel to determine if the proposed action requires board or stockholder approval. This has been another episode of Time is Not on Your Side. Please stay tuned for additional episodes. See you next time.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.